You have the floor, sir.
Good afternoon, Mr. President, distinguished members of the Court. It is my honor to appear before the members of the International Court of Justice, the main judicial body of the United Nations, in representation of the Republic of Panama. On behalf of my government, I would like to convey the high sense of responsibility with which the Republic of Panama approaches the legal question submitted by the International Labour Organization. The Panamanian state appears before this court motivated by the conviction that the consistent interpretation and application of international law, especially in the area of a fundamental labor right, provides legal certainty to states, employers' organizations, and workers' organizations. The Republic of Panama upholds before this court a position based on history, law, and international practice, always seeking to strike a balance between the protection of fundamental rights and the state obligations. From this premise stems Panama's definitive conviction that Convention number 87 does not regulate neither expressly or implicitly the right to strike, which is exclusively a matter for the domestic law of states. On November 10, 2023, within the framework of its governing body, the International Labour Organization requests this court to issue an advisory opinion. The resolution raises the following legal question before the court. Is the right to strike of workers and their organizations protected by the freedom of association and protection of the right to associate Convention number 87 of 1948? With regard to this court's jurisdiction to hear advisory requests, the Republic of Panama upholds that pursuant to Article 65 of the Statute of the Court, it is within its discretionary powers to accept or reject requests and, where appropriate, to define the scope of the legal response as the court deems it to be appropriate. It is important to recall that the preamble to Convention number 87 is based on a normative tradition that refers to the ILO Constitution of 1919 and the Declaration of Philadelphia of 1944. That declaration proclaims, among other principles, the affirmation of the principle of freedom of association, and that freedom of expression and association is essential to steady progress. These historical and normative references constitute, according to Panama, a relevant interpretative context that the court should take into account when examining such matters. Respect for the sovereign consent of a state is a cornerstone of international law. Accepting a broad interpretation of Convention number 87 would be tantamount to opening the door to unagreed obligations, which undermines legal certainty and erodes confidence in the multilateral system. In Panama's case, historical experience shows that strikes preceded freedom of association and its illegal regulation. The historical constant has been the conception of a strike as a collective and concerted suspension of work for purpose of asserting rights, without any rules or regulations to protect them in their beginnings. Freedom of association refers to the right of workers and employers to organize. Strikes, on the other hand, are means of collective action with economic and political implications. Equating these two rights could imply an interpretation that does not reflect the express will of the states in adopting Convention number 87. The first strike in Panama dates back to the mid-19th century in the context of the development of capitalism in the Isthmus. Among the events that illustrate these assertions are the construction of the Trans-Isthmian Railroad beginning in 1850 and the agro-industrial exploitation of bananas in the provinces of Chiriquí and Bocas del Toro. In 1853, workers at the Pacific Mail Steamship Company, based on the island of Taboga, went on a strike to demand higher wages. Such action was repeated in 1855. Similar movement ensued. Railroad workers went on strike in 1868 and 1869. Tobacco workers in Panama City did it in 1880. And strikes on the railroads and docks took place in 1883 and 1895. The Panamanian labor movement began to take on a more organic structure in the 1920s, with the creation of the Federación Obrera, Workers' Federation, the Sindicato General de Trabajadores, General Workers' Union in 1924, and the emblematic tenant strike of 1925. These collective actions mark a turning point toward the institutionalization of labor demands. Since the founding of the Republic as an independent state, Panama has had 4 constitutions, those corresponding to the years of 1904, 1941, 1946, and 1972. The constitutions of 1941 and 1946 expressly recognize the right to strike, including the possibility of a special restriction when declared in public services, reserving the regulation of the exercise of this right to the law. In addition, both constitutions recognize the right to unionize, both for employers and for workers and professionals. The right to strike, as enshrined in the 1946 Constitution, has been preserved unchanged in the current Constitution of the Republic of Panama, adopted in 1972, and has remained so after being amended in 4 occasions, in 1978, 1983, 1994, and 2004. The Labor Code of the Republic of Panama, in force since 1972, regulated the constitutionally established right to strike. It is the product of a legislative development that was markedly protective of collective labor disputes. Mr. President and distinguished members of the Court, 2 key conclusions which are essential to our position arise from this historical development. First, in the Republic of Panama, strikes originated as a social and economic phenomenon that predated organized and legally recognized freedom of association. Second, the regulation was developed within Panamanian domestic law in response to national realities, not as a direct consequence of international law or ILO Convention number 87. The Panamanian state has ratified international instruments that reinforce this right, although they do not necessarily derive from the Convention number 87. In 1966 and 1967, the Republic of Panama ratified ILO Convention number 98 and number 87 on freedom of association and collective bargaining. In both cases, it took due note of the fact that the text of Convention number 87 does not expressly mention strikes, and it is therefore convinced that the regulation did not arise from that instrument, but such was the result of interpretations by the ILO supervisory bodies. In 1976, Panama adopted the International Covenant on Economic, Social, and Cultural Rights. In the regional context, it is also important to note that in 1992, the Republic of Panama approved the additional protocol to the American Convention of Human Rights in the area of economic, social, and cultural rights, known as the Protocol of San Salvador. Article 8 expressly establishes that the state parties shall guarantee the right to strike, exercised in accordance with the law of each country. It should be added that international human rights treaties and conventions ratified by the Panamanian state form part of the constitutional bloc by virtue of the ruling handed down by the plenary of the Supreme Court of Justice in exercising constitutional control throughout the country. Mr. President, distinguished members of the Court, it is necessary to emphasize that the right to strike and its practice do not appear expressly regulated in the fundamental instrument of the ILO. This includes the ILO Constitution, the Declaration of Philadelphia, Convention number 87 and 98, as well as the 1988 and 2022 Declaration of Fundamental Rights and Rights at War. The Panamanian state holds that Convention number 87 should not be given an interpretation different from the will expressly adopted by the states. It further holds that technical guidelines cannot be converted into binding legal obligations. In the view of the Republic of Panama, when directives are issued regarding the right to strike or when national provisions are assessed, such pronouncements do not create law, but rather constitute interpretations intended to facilitate the application of the conventions. In the present case, those guidelines pertain to the right of association, a matter distinct from the right to strike, so that admitting the contrary would impair the principle of tripartism and the normative functions that rest exclusively with the member states. The right to strike is part of the development of the domestic law of member states, taking into account the particularities of each labor system. However, it does not reach the dimension of a universal commitment with the significance that an international treaty entails, as an authentic expression of the collective will of the members to bind themselves through such an instrument. Convention number 87 must be interpreted in light of its object and purpose, which are confined to freedom of association and to the protection of the right to associate. While the preparatory words of a convention may constitute a relevant interpretative source, they do not confer authority to expand its scope, nor to establish obligations that the state did not expressly adopt. Consequently, Convention number 87 protects freedom of association and the protection of the right to associate, but cannot be considered to implicitly include the right to strike, without exceeding the original intention of the states in ratifying it. The principle of consent of the states and the objective and purpose of the Convention itself. The position of the Panamanian state is that strikes as a means of pressure in hands of the workers, whether organized or not, have legal, political, and economic repercussions that go beyond simple association. For this reason, they cannot be understood as falling under Convention number 87 concerning the right to associate. Therefore, strike action is only regulated within the laws and particularities of each country, taking into account its cultural, economic, and social conditions, and not through an extensive interpretation of an international legal instrument such as Convention number 87. In the Republic of Panama, the recognition and regulation of strikes have been essentially an internal process embodied in the Constitution, the Labor Code, and special laws. Therefore, the legal basis of this right to strike in Panama rests mainly on national law and not on an extensive interpretation of ILO Convention number 87 concerning freedom of association and protection of the right to associate, 1948. In light of the foregoing background and analysis, the Republic of Panama respectfully submits the following considerations. 1. Striking is an autonomous right with its own history, effects, and limitations, distinct from mere union membership or formation. 2. International legal certainty requires that states be bound only by what they have expressly accepted, in accordance with the principle of sovereign consent, recognized in international custom and in the Vienna Convention on the Law of Treaty, 1969. 3. That interpreting Convention number 87 is an extensive manner so as to infer the right to strike could impose obligations not agreed upon by the member states, thereby undermining the literal, teleological, and systematic interpretation of the Convention, and affecting the coherence and legal certainty of the international labor system. Mr. President, distinguished members of the Court, the Republic of Panama concludes its intervention by recalling that the right to strike was originally a social phenomenon rather than a legal norm, and that its subsequent regulations arose from domestic law, not from international treaties. Consequently, the Republic of Panama reaffirms that Convention number 87 does not expressly regulate the right to strike. From a legal perspective, Panama asserts that respect for the principle of sovereign consent of states and the rules of treaty interpretation enshrined in the 1969 Vienna Convention requires that international obligation be expressly assumed. Recognizing the right to strike as implicit in Convention number 87 would alter its scope and undermine international legal certainty. At the legal level, Panama stresses that the strength and legitimacy of international labor normative system lie in the tripartism of the ILO. In view of the foregoing, the Republic of Panama respectfully requests this High Court to determine definitively and unequivocally that the right to strike is not implicit in Convention number 87, and that its regulation corresponds solely to the domestic law of the states. Such a pronouncement is indispensable to preserve the integrity of the Convention, to ensure the stability and legal security of the international system, to reaffirm the principle of sovereign consent of the states, and to safeguard the legitimacy of the normative system of the International Labour Organization. Thank you very much, President.